Hi, I'm Peter Tragos, host of the Lawyer You Know podcast and YouTube channel. The saying goes, everyone hates lawyers until you need one. Well, I'm here when you need one to answer your questions and give you insight that you didn't know you needed. Along with my partners, Pete Sardis, the professor, who has a finance and business background, and George Tragos, my dad, and the consigliere, a criminal defense giant, we can answer any questions you have.
Hi everybody, Pete Sardis for the Lawyer You Know, here to do a trial update for Aiden Fucci in the death of Tristan Bailey up in Jacksonville, Florida. What I want to do is I want to talk about some of the motions that were filed by the defense this week, the implications that those motions might have to this trial, and we're going to talk about what we can expect to see in the months coming up to the November trial date. But before we do that, as always, if you enjoyed the video, please give me a thumbs up. If you're enjoying this series or any of the other videos that we do here at the Lawyer You Know, please subscribe to our channel. And as always, if you have questions and comments, please leave them down below for me. All right, let's talk about what's going on. As we all know, Aiden Fucci is the 14-year-old boy that has been charged as an adult in the murder of Tristan Bailey. If you recall, she was stabbed about 114 times up in the Jacksonville, Florida area. Aiden was arrested and has been sitting in custody for about a year now. He is scheduled for trial in November of 2022. This last week, the defense filed a number of motions for the court's consideration. And let me just say, before a trial happens, you expect a motion practice, meaning I expect that the defense, the prosecution, both sides are going to file motions, either asking the court to give either one of the parties some sort of redress. Either, judge, we need you to preclude this, or we need you to force this to happen. Or in the alternative, motions that are filed to really put the court on notice about the issues that are going to be coming up in a specific case. And that's what the defense has done here. And what they have filed is this. I want to talk about the motions they filed, and I want to tell you about the implications about those motions and how I believe the court is going to view those motions in regards to this upcoming trial. The first motion that the defense filed was a motion to preclude prejudicial emotional outbursts in front of the jury. All right. What does that mean? The defense is basically asking that the friends and family of Tristan Bailey that are going to be in the courtroom during this November trial, that they'd be admonished by the court so that they don't have emotional outbursts in front of the jury that could somehow prejudice Aiden Fucci during his trial. So what does this really mean? The court is going to admonish the lawyers most likely and tell them, look, tell your witnesses, tell the people that are going to be in the courtroom that are part of your individual sides to have some sort of decorum. Recognize that this is going to be an emotional trial. We are talking about the murder of a 13-year-old girl. So at this point, there is no way that the judge is going to look at somebody inside of the courtroom or that's in the audience and say, no crying, no emotion, things like that. He's not going to do that. But what he is going to do is he's going to say, have some sort of composure. We realize there are going to be emotional moments in this trial, but we don't want people howling or uncontrollably crying in the audience, so that's something that the jury can see. The truth is, if you become emotional, we can either take a break, or number two, we are going to ask you to step out until you've gained your composure. That's what I expect we're going to see from the judge as an order on this particular motion. The second motion that the defense has filed is to exclude cameras from the courtroom, the purpose of which, they say, is to avoid the prospective jurors somehow feeling that they can't be open and express their bias or prejudices while on camera. This is kind of an interesting motion. The Florida judicial system is very clear. The rules actually say that in Florida courts, the courtrooms are open, and in fact, a camera cannot be excluded from a trial. Meaning that the media's presence or the public's presence in an adult criminal trial is the norm, not the exception. Now, there are some things that the court has the right to do in order to exclude media, especially when there are sensitive issues. For example, in a matter where a child is testifying, absolutely the courtroom is going to be closed. They're going to clear the audience. They're going to take the cameras out of the courtroom, and they're going to have those proceedings, what's called, well, interestingly enough, in camera, meaning outside of the presence of other people. Other than that, the court has the right to make some limitations in order to avoid prejudicing the defendant. Now, there are some rules in place in Florida that I think will alleviate the issues that are raised inside of this motion. First of all, the rules are pretty clear, and between us, the media has always been very conscious about showing the faces of jurors or prospective jurors on camera. The courts don't allow that. The media has always been very respectful. They don't show the faces of jurors. If you go back and look at media footage in Florida, you may see the cameras kind of panning, but what you'll see is maybe the arms and legs or just the parts of the jury in the jury box, but they're not actually showing their faces. They may sometimes blur their faces out. The second thing that is a protected right in Florida is that camera or those cameras, the media, can be in that courtroom from any time the court goes live until the court adjourns for the day. Meaning they're allowed to be there. You could walk into this courtroom and sit down and watch the entirety of these proceedings just like anybody else. And the media especially really fights these motions when they're asked to clear cameras from the courtroom, because from their perspective, this is the open courtroom, the sunshine law that Florida has that allows transparency, and especially from the media's perspective, this is their story. If they can't have a camera in there, obviously it doesn't make their story as impressive as it would be with that media presence. So they're going to fight this. I expect that we're going to see briefs from the media outlets in response to this particular motion. But at the end of the day, I think the judge recognizes that this is going to be a highly publicized case. I believe that the court, depending on who shows up for trial, may make some limitations or place some limitations on the media. For example, if 60 media outlets show up and they all want to set up cameras in the courtroom, the judge is probably going to say, that's extreme, we can't do this, it's going to be prejudicial to the defense. So what he may do is say, we're going to put in 2, 3, 4 cameras, whatever the case may be, and you all as the media will share the footage however you deem appropriate. Some courthouses actually have cameras inside of the courtrooms that broadcast to a media center. That way, all of the cameras are actually pointed towards the video screen that is a direct live feed from the camera, and the media outlets can then take whatever they want from that footage that is being directly fed into the media center. So I'm not sure if Jacksonville actually has this particular setup. There's a good chance that they do. Other than that, I anticipate the judge may make some comments to the jury indicating that the fact that there is a media presence and the fact that the media is going to be present for the entirety of this trial should not affect the jury's perception of the evidence, and they in fact should judge this case on the merits based on what the prosecution can or cannot prove. Again, there's also going to be some jury instructions, because they're standard in the state of Florida, that admonishes the jury when they're actually selected and tells them, avoid media contact. When you go home, don't turn on the news, don't talk to your friends and family, don't check your social media, simply because the chances of you being tainted by something you see in the media may very well affect this trial and force this whole thing to start all over again. There are safeguards in place to ensure that media's presence does not overly prejudice the defense. So do I think the court is going to issue some order? I do. Do I think the judge is going to exclude cameras from jury selection? No, I don't. Do I think that we're going to have a video feed of this entire trial starting in November, presuming it goes? Yes, I do. The one thing that the defense has asked for in that motion that I believe is going to be granted is that the defense has asked that the prospective jurors, meaning when they bring a group of people in for the lawyers to select the jury from, they're asking that those people be referenced by number, not by their name. Now, this is actually very common. And what happens in most jurisdictions is a juror is issued a juror number, and when people go in and out of the courtroom as prospective jurors, the bailiffs or the courtroom security or the court will speak to them based on their juror number. Now, in cases where there's not a lot of publicity, I may know juror 306 is Samantha Smith, and I may say Miss Smith because there's no reason not to address that person by their name. But in the case where there's a lot of media presence and there's a fear that the media may actually go to the prospective jurors' homes and try to get some sort of story from them, you're probably going to hear, Juror 107, can you please tell us how you feel about this or how you feel about that specific issue? And I think the judge is going to grant that. I think that is something that happens on a regular basis in Florida courts, especially when we're talking about highly publicized trials. Okay, the third motion that the defense has filed is to ask the court to preclude the autopsy photographs from going before the jury. Okay, I've got a lot of feelings on this one because I've actually had this fight more than once in a trial. The reality is that the rules in Florida are pretty clear. Any evidence that tends to prove or disprove a material issue in a case is considered relevant. Relevant evidence is admissible if it is not more prejudicial than probative. So meaning, if evidence has probative value, but the value of that evidence does not over prejudice the defense, it's coming in. The autopsy photos are going to be relevant, number one, to the case because the pathologist and I presume the wound experts are going to need the photographs in order to be able to testify, to be able to show things like the pathology of how the person died. The wounds, the angles of the wounds, the force needed to inflict specific wounds, on Tristan Bailey. Those things are absolutely relevant and material to be able to show how the wounds happen, and the prosecution's perspective is going to be that Aiden Fucci was the one who was capable of making these wounds. For example, he's right-handed. Based on his height and his arm length, whatever the case may be, this wound is something that the physics says could have been inflicted or was inflicted by him. Do I think that there's going to be a limitation that the autopsy photos are not going to be shown in this case? Absolutely not. I will bet that all the autopsy photos are coming into evidence. Actually, let me change that a bit. I bet that autopsy photos are coming into this case. Now, they may not all come in. And the reason I say that is there is a rule that cumulative evidence isn't admissible. In other words, if I have three of the same picture, I can't put all three pictures in. That is more prejudicial than it is probative, but I can pick the one picture I want to use and put it into evidence. There's a gray area though for the cumulative rule. And the gray area in Florida says that different angles, photos that depict different things, even though they may look similar, are not cumulative because they're showing something different. For example, a picture of a body in one position, then a picture of the same body in a different position are two separate photographs. There are two separate pieces of evidence. Normally, the courts would allow both of those pictures in because they depict different angles of the same thing. Sometimes there's a zoom in and a zoom out, meaning you'll see the body and a wound from far away, and then you'll see a close-up of that wound. Again, even though they may be depicting the same thing, they're different vantage points of the same thing, and normally these are not cumulative. Normally these are considered different angles, and the court will allow them in. I am expecting a lot of autopsy photos to go in. They're going to be prejudicial to the defense. There's no way around that. Frankly, everything that the prosecution does is prejudicial to the defense, and that's not the rule. The rule is whether or not the photographs are more prejudicial to the defense than they are probative to the issues in the case. And I promise you that the autopsy photos don't fall into that category. They're coming into evidence. There may be some exclusions. I do believe that the court may admonish the press to not photograph autopsy photos of Tristan Bailey. Obviously, when you're having an autopsy done, you're nude, and some of those things should not be publicized. I believe that the media will obviously honor that request because they don't want to, number one, put photographs of a dead child in the media. Number two, technically it is photographs of the victim, so they're not allowed to put those out in the media since she is a minor and a victim in a criminal case, even though she's deceased. But ultimately, you're going to see that these photographs are going to be placed in front of the jury, and they're going to see them. The final motion that we see from the defense is a motion to preclude a submission of the indictment to the jury. This motion is interesting to me, and the reason I say it's interesting is the indictment is the charging document. In Florida, there are two ways you can charge a criminal defendant, either with an information, which is basically an attestation from the state attorney's office, or by indictment, which means a grand jury has actually made a decision that there's probable cause to prosecute someone. In Florida, capital cases, meaning a case where somebody's dead, has been murdered, are normally brought before the grand jury and an indictment is passed down. The judge is going to read the indictment to the jury venire, meaning the panel of people that the jury will be picked from. It's important because if you don't read the jury venire, the charging document, they don't know what they're there for. You don't want to be in a situation where you start the trial and they're like, wait a minute, this is a murder trial of a child? I can't be on this jury. My cousin was murdered, or I'm sensitive to children, or I can't be part of a murder trial. I just am not willing to do it. Whatever reason may be. So right off the bat, the judge is going to read the indictment, the charging document, to the jury. Normally in criminal cases, that charging document goes back to the jury for their consideration during the deliberations. The judge will say it's not evidence, but it is what they're charged with. So that's what the prosecution has put forth as the basis for the criminal charge. I think it's odd that the defense has asked for this because at the end of the day, the jury's going to hear it anyway. I think what they're trying to avoid is the cumulative nature of the jury continuing to hear that Tristan Bailey at age 13 was stabbed 114 times, and to wit, they believe that Aiden Fucci is the one that committed the crime. But I don't think that the judge is not going to read the indictment to the jury pool when they start the case. I'm certain that the judge is going to instruct the jury based on what the charging document is and what the government is alleging. And they're going to have, obviously, the jury questions, which is the verdict form that talks about every element necessary to prove, murder and the lesser included counts of, involuntary manslaughter, voluntary manslaughter, things like that. So I'm guessing the jury's getting the indictment, but we'll see how that goes. The judge, might try one way or another to try to limit what parts of that indictment go in. Again, the judge has the right to make modifications, again, to protect the defendant, to ensure that his trial is fair, and to make sure that the evidence and that the information coming before the jury is not more prejudicial than it is probative. So at this point, that's where we are. I anticipate that the judge is probably going to have a hearing on this motion, and there are probably going to be more motions being filed before the November trial. There is a pretrial schedule in October, which is the next time I believe we're going to see Aiden Fucci in court. We'll cover that for you. I'll let you know what we find in that respect. But at this point, if you have any questions about what we've talked about, if you have any comments about what you think is going to come up in this case, for example, do you think that there's going to be any other motions that are going to be filed by the defense or by the prosecution? Let me know what your thoughts are. If you have any specific questions about what we've talked about, leave those questions down below. And as always, if you've enjoyed the video, give me a thumbs up. If you enjoy this series, please subscribe to our channel, and questions and comments below. We'll talk to you soon. Thanks.
Thanks for watching this episode of The Lawyer You Know. If you like this content, please share it with your friends. Make sure you subscribe to our page and like our videos. If you want some interaction, get in the comments and we'll be sure to get back to you. If you want to know any more information about our firm or this page, you can find out in the description or visit tragoslaw.com. We post multiple times throughout the week, so make sure you hit that bell so you can get the notification and not miss out on the next episode.